It sets out two pathways to follow. First, to revitalize the First Nation laws and legal systems, and second, to reform Canada's criminal justice system. The two pathways include 25 strategies with corresponding action items. These are flexible, First Nation-driven approaches to long-standing justice issues. These action items are the result of First Nations input and expertise, with concrete recommendations that include recognizing multiple jurisdictions, supporting First Nations knowledge exchanges, and other principles. What we are sharing today is turning a broken system for positive change so that we so desperately need to finally fix a broken system. Canada is entering a new era, one of economic, political, and cultural change. This can be a new era of justice for First Nations. We have the idea, we have the recommendations. All we need now is the political will from this country to advance the historic national First Nations justice strategy. Chimigwech, thank you so very much.
Our next speaker will be Regional Chief from BC, Terry Teegee.
Thank you. Deneza, Tsekuza, Skyza. First of all, I want to acknowledge the territory of the Algonquin Anishinaabe people, and I would like to thank them for allowing us in their territory. As the National Chief said, this is a very important day. It is a day that marks the turning point, a day that we share a national roadmap for what will bring about change for our people. I'm proud to be here today to speak at the Assembly of First Nations National First Nations Justice Strategy and the work that brought us to this point. First of all, a little bit about the background of BC Justice Strategy. As National Chief stated, we have a justice problem in Canada. When it comes to First Nations, the system has not been just for our people. And we have seen the devastating effects of the broken system for far too long. In my region of British Columbia, our leadership have advocated for hard to review the flaws of the system and develop alternative approaches. The BC First Nations Justice Council was created in 2015 by the BC Assembly of First Nations, the First Nations Summit, and the Union of BC Indian Chiefs. Through its work, the BC First Nations Justice Council draws on our traditional practices and First Nations customs to reimagine what justice should look like in our communities, replacing the colonial system with our traditional ways of knowing and being. That means uplifting values such as respect, empowerment, and trust. In 2020, BC First Nations Justice Strategy was jointly published by the BC First Nations Justice Council, BC First Nations Communities, and the province of British Columbia. That document provided 42 actions along two paths. 1, reform of the current justice system, and 2, restoration of the First Nations legal traditions and structures. It became the model for what we can share today, the Assembly of First Nations National First Nations Justice Strategy. We have seen these principles in action in British Columbia, and we know the model produces tangible, positive results. Last month, for instance, the BC First Nations Justice Council announced the launch of a new provincially approved training course for police that provides knowledge and teachings to advance First Nations cultural competency. Knowledge exchange at this level will help reduce unconscious bias, a great contributor to overrepresentation of First Nations in the judicial system. Other action plans involve inclusion of elders and knowledge keepers in the justice system and structures, funding for wraparound supports for exiting the justice system, and other holistic approaches. Now we call for implementation and support. Many years of expertise and experience have gone into the development of the National First Nations Justice Strategy. We know these approaches are sound, and we have a blueprint for the concrete actions needed for all levels of government and institutions. As the National Chief said, said, we are in an era of change. We must ensure that this era of change is for the better. We have the data and we have the action items. Now we need the commitments from the Government of Canada to provide sustainable, predictable, and adequate funding for the implementation of these transformational recommendations. In conclusion, on behalf of the BC region and also as a portfolio holder for the Justice File, I'm proud to be here to support the National First Nations Justice Strategy. Along with the National Chief, I look forward to having the opportunity to meet the Minister of Justice and Attorney General of Canada, the Honourable Sean Fraser, to discuss the next steps for implementing the important document that is a milestone for First Nations and the justice system. Thank you. Merci. Thank you.
Thank you, Regional Chief. Our next speaker is the Chair of the BC First Nations Justice Strategy, Corey Wilson.
Thank you. I'd like to acknowledge that we're on the unceded territory of the Algonquin and Anishinaabe people, and thank the National Chief and Regional Chief for the work, all of the hard work that's gone into this strategy. As was mentioned, British Columbia has had an Indigenous justice strategy since March of 2020, and what we know for sure is our strategy works. The strategies and the things that we are doing and the 25 strategies and the 43 lines of action, implementing those has shown actual change, systemic change in the system. Having a national First Nations justice strategy is going to complement what we're doing in British Columbia. And the reality, one thing we know for sure is that we have to do all of this work together. Together as First Nations people, together as Indigenous people. We need to have federal partnerships, provincial partnerships, territorial partnerships, and we need all of the actors and players in the current system to do their part, because this is not going to happen without everybody doing their part. And we have a roadmap. We know how to make this happen. For example, the First Nations Justice Strategy, by the end of June, will have no more wait list for GLADU reports. We have a pre-diversion program that is happening that has made substantial change and created a partnership with the RCMP in a way that hasn't happened before. We have all kinds of countless examples of how this has worked and how we can move this forward. And with the recognition too, and this is one of the calls to action, not only is it important to actually fully implement these justice strategies, to put funding and resources and time and energy into these strategies, because the end result of that will be a massive cost savings in times of fiscal crisis that we see at the provincial level, federal level, and territorial level. If we take one Indigenous woman, who 50, as was said by the National Chief, 50% of the women incarcerated in Canada are Indigenous. It costs $255,000 a year to keep that woman incarcerated. And if she has children, you're likely also paying to keep her children in care. So we can right the wrongs of the past. We can change this system, truly make systemic change if we are bold and courageous together and we do what we need to do and what we know we can do. We don't need any more studies. We don't need any more, we can go back as far as, I know in the National Indigenous Justice First Nation Strategy, they went back to what was said in RCAP. We know the answers to the solutions to the overrepresentation of Indigenous people in the justice system, but it's time we actually action it. And I call on everyone to do their part and to work together with us, alongside us. It needs to be First Nations led. It needs to be trauma informed. It needs to have a foundation of diversion, and it needs to have all of us working together in the same direction. And everybody, as I said, can do their part, whether they're Defense Council, Crown, police, whichever level. So I really hope, and I know at the First Nations Justice Council, we are open to sharing all that we've learned. We're open to having conversations. We're opening to lend our support and tell you all of the great things that happened, but tell you also where we made some mistakes so that you avoid those mistakes. And we look forward to working with the federal government and provincial governments and territorial governments to further implement the BC First Nations Justice Strategy as well as the National First Nations Strategy. Thank you.
Awesome. Thank you, Corey. What I'd like to do is open up the floor to questions.
Question for Regional Chief TG. You're dealing with a lot, Leslie Pescafini from the Canadian Press. You're dealing with a lot in the province right now with their legislation. Are you similarly worried about what's happening federally with Bill C-5?
Yeah, most certainly. With the bills that you're talking about provincially in British Columbia is Bills 14 and 15, which were created without much consultation with First Nations in British Columbia. Similarly, we're seeing the same here federally. We're very concerned about legislation that would fast track projects. You know, the ability to make decisions within our First Nations communities on projects is very concerning because there's no ability to have not only deep consultation but consent of projects, which isn't compliant with the Declaration of Rights of Indigenous Peoples Act provincially and in the province of BC, or United Nations Declaration Act federally. So certainly we're very concerned. We've done a preliminary review, legal review of the Act itself, and we're very concerned about the Act itself.
Able to share what was in that legal review?
At this point, I guess I could say is that it isn't complied with the context of the United Nations Declaration Act. I also am not only on the Justice file, I'm the chair of the Chiefs Committee on the United Nations Declaration Act. I think you know what the provisions or what we do see with the Act provincially and also the Federal Act is that there's no ability to make a decision on projects, especially if they're fast-tracked, in terms of free, prior, and informed consent. So that is in direct contradiction of the Declaration. So at this point, I think we're very concerned with both legislation and also other regions and other provinces, such as Ontario and perhaps Nova Scotia have similar acts. So at this point, I think, nationally, we need a national discussion, which we will have on Monday with the other chiefs across this country, and perhaps there will be even more concerns from other regions.
Another one for the National Chief just on the meeting on Monday. Online, a lot of people are bringing up the last time that there was an emergency chiefs meeting with Sean Atleo, who was told by chiefs, don't meet with the federal government, and then met with the federal government. Do you commit to following the direction that chiefs give you on Monday?
Look, I always, there's always a diverse of, opinions with First Nations. And at the same time, I think one thing is common, is that respect needs to be shown to First Peoples in this country. And time again, it isn't. Many times with all of these bills right across the country, right across the regions. And look, I take direction from chiefs in assembly. When they pass motions, we do things in a democratic way. And I follow chiefs' resolutions and chiefs' motions from chiefs in assembly. So that is how the AFN works. And at the same time, I do know that ramming through bills without giving First Nations time to speak is not a way forward for our country. I think that we can all do better. I also believe Canadians should have a chance to voice their opinion one way or another on specific bills in this country. And ramming through legislation, I think the last time that this happened was during the pandemic. We had an unforeseen virus that was coming at us that we knew nothing about as Canadians, right? We didn't know it was going to hurt us, hurt our communities. And of course, as First Nations, we were very on guard because we have limited access to hospitals. As many of you know, our infrastructure's half that of Canadians. And we understand, and we don't want to get in the way of progressing this beautiful country forward. We've always stood forward and helped Canada, but at the same time, when there's bills being rammed through that could affect our rights, and we just got the bill on Friday, a draft, the draft bill. We need time, of course, to legally review it, politically review it as well, and we're not being given that time.
Laura Osmond, The Logic. On the same sort of thread, what kind of options are on the table that you'll be discussing in that meeting on Monday?
Look, I'll wait for the chiefs to hear that. You'll hear them as they come in, and I'm sure the chiefs will come up with the best path forward. They always do.
So the legal review that's already been done, do you see any way that the government can move forward with this in a way that is compliant with the UN declaration, given that they're looking to rubber stamp projects before some of those key details are in?
Look, I'm going to wait until Monday to have a more wholesome discussion. We're still in the middle of a review. We have, of course, a preliminary review. I know BC's also got their review. People are trying to review this, and it's only been a few days, so I just ask for some time.
Global news. Last week, the AFN voted to join the Algonquin Anishinaabeg's human rights complaint against the federal government over the Indigenous Business Directory. Why did the AFN decide to intervene, and what do you hope the outcome of this action will be?
Well, the executive, we like I said, we talk to our chiefs, and sometimes when there isn't a chiefs meeting, we go to our executive committee. So our executive committee instructed that we join that, and there is a lot of pretendians in this country that utilize that and it hurts First Nations people. It hurts, that small percentage that's to go to First Nations, to work, and it would work if it would work well, but they do, so yeah, I'll leave that.
Is like pretendians have been known for decades now. How frustrating is it to go to the Human Rights Tribunal to deal with change when it comes to dealing with pretendians?
Well, I can't, I'm going to leave that for the courts to decide, but for sure it has been very detrimental. I mean, I think people are, I don't know if you want to add something further on that, on pretendians, but.
Sure. It's certainly a big issue because people who are not Indigenous are taking the space of legitimate First Nations peoples. And certainly we're seeing it, just for example, that there could be opportunities such as procurement, as we've all seen with the NAVCAN issue. So it's a real big issue that potentially could displace our people who have opportunity for economic development or any other place within society. And that is a real problem, and certainly many of our people across this country are identifying as a problem, because we need a space that not only that is supposed to be for First Nations or Indigenous peoples, and that is taken up by people and or companies that are illegitimate. And that's a big concern for many First Nations across this country.
So, First Again, News, I do have a question about UNDRIP and free, prior, informed consent, which any of the three of you can answer, because I know you're all well versed in the topic. So, there's been a lot of discussion, debate. I know the Justice Minister was kind of caught out of cabinet and walked back some words. So, in your interpretation of UNDRIP and free, prior, informed consent, does this mean First Nations have a veto on projects that may affect their lands?
So I spoke in the legislature in British Columbia on November 29th in 2019 in regards to this notion of veto and I suppose a definition. What we stated there, and I'm certain it applies here and federally across this country, is that no government has a veto, meaning that when we come to a decision, all governments come into a room to make a decision together. And I think, First Nations certainly as a part of this need to be part of the decision-making process. And I think in some way, and it comes down to projects, and certainly, we were hearing about the national discussion of projects that have national implications, such as pipelines, and those projects are very difficult. And I'm not naive to the fact that you do need First Nations across the territory or wherever the pipeline may be, and I've been involved in some of that in British Columbia, and certainly. I think the way that we see it is that we need to all come together to make a decision.
So as a follow-up, I guess, which is a hypothetical situation, but it actually has happened where you do get a large agreement with First Nations, with industry, there's jobs and everything, but you do have one particular First Nation in the area that just can't make that bridge to get to the project, or they feel doesn't their members wouldn't do them good or something like that. How do you get to consensus then from that point?
I think that is a good point. It speaks to the challenges of not only development of projects, but I think in some way you need some sort of process after the fact, or some sort of dispute resolution, if you will. In regards to how to get to either yes or no. And especially in projects that have consequences. Now, like COVID, this is another existential issue where the Trump administration, we're in the middle of a tariff war, and there's these external pressures upon Canada, British Columbia, and what have you, where there's a big push for many of these projects. However, far too often, we've seen this in British Columbia, we've seen it in Canada as well, is that it's at the expense of our rights, title, and interest. More often than not, it comes down, when projects are approved, it comes down to at the expense of our rights, title, and interest, and that can't happen anymore, because in the end, if we don't end up in a place that we are all agree upon, in their haste, I would say, like British Columbia, Ontario, Canada, in their haste to develop fast-tracking legislation, they're fast-tracking the legislation process. It's probably going to take a lot longer to get approval for some of these projects, because we're going to end up in court, and this is where we end up. And yeah, go ahead.
No, sorry, I wanted to finish. You were saying something. So, Riddhi from the Hit Times. Just on the same point, I wanted to understand. The National Chief has had meetings with the Prime Minister, and Prime Minister Mark Carney has maintained that these projects will happen with the consensus of the provinces, of First Nations. When you met him, what kind of assurances or what kind of discussions did you have with him, and do you see in future having a positive dialogue with the Prime Minister, or maybe the Indigenous Services Minister, Mandy Kalmasti, or the Crown Indigenous Relations Minister? Do you have any more meetings planned, and do you see a more positive reception in that area?
Well, certainly, I keep hearing that they want to push through this legislation, right, to the end of this month. And I think that's the wrong way to go. And even though they have committed to meet with First Nations leadership, they've committed to that for this summer, the Prime Minister himself will meet with chiefs. I think you need to do that before you pass any legislation so that they can have input. And look, there's going to be a diverse opinions across this country, even with Canadians, but I think let's respect each other. The other thing that I'll say is when the provinces and the federal government meet, and even national chiefs before me, I feel for them, they were always left out of those discussions. So you want to have this big national discussion. You don't want to end up back in court. You don't want to have civil unrest. Why not just invite us to the table then? Let's talk, right? Isn't it better to talk through things rather than always being in litigation? But it seems like First Nations always need to litigate. And then we get process and results later. Does Canada want to change that or not?
Right. And in your engagement with the Prime Minister's office, just specifically, do you have any more meetings lined up with him, and what's that response like?
Well, I'll always speak to governments that want to work with First Nations, of course, and I know that, we've been also speaking to the opposition. We've been speaking to different members of Parliament, independents. We'll always speak to everybody in this house to try and make a better Canada. I mean, we all want to make a better life for our kids. But when we're excluded and left out of tables, and our leadership is left off of tables, I don't think that's a good way to start. And I think we can, if Parliament's listening, hold off and allow for proper discussion on this bill.
We have time for one last question.
We're starting to see some success stories in terms of First Nations partnering, having part or whole ownership of projects, things moving forward with Indigenous buy-in. Do you feel like this bill is a setback in terms of the kind of progress we've seen made over the last several years with private Indigenous partnerships?
Look, I think it's not about the bill itself, it's about the process. And I think that it's, ramming something through when you should be hearing from Canadians, from industry, from First Nations, and just ramming something through is the wrong way to go. We shouldn't do that as a country. And look, we take the summer take the time to listen to First Nations, take the time to listen to Canadians, and I think that'll make it a more united country. I mean, I think Canadians want to have that conversation. First Nations want to be at the table to have those conversations. I'm hearing from chiefs over and over again, well, I want to come and present. Give them the time to come and present in Parliament and of course in the Senate, and let them get their points across or make it a stronger bill. Right? Alicia, last question.
Question for you. How was your meeting yesterday with Crown Indigenous Relations Minister? What did you talk about there?
Oh yeah, I met with. I'm like, what was yesterday? It was good. I mean, I think that her and I need to do ceremony together for sure. It was our first meeting, and lots of issues to work through. There's still lots of land issues that she needs to work through in this country. And yeah, we had a good first meeting, and certainly, we have a lot of work to work through, I think, on land issues, on rights issues, on having a full seat at the table. I think if this country wants to get serious, make space for First Peoples at the decision-making tables. We're not an afterthought. We're a founding partner in this country, and we need to be treated as such. So thank you very much.
A good example of positive results is what we have in British Columbia called Section 7 agreements under the Declaration of Rights of Indigenous Peoples Act. There's been 2 in the Tahltan Territory, which allowed for the development of mines. And I was fortunate enough last Thursday to witness a 3rd one in the Chilcotin Territory in regards to Taseko. And Taseko has been in court for literally decades, and they signed a Section 7 agreement, which allows them consent-based decisions whether they go ahead with the mine or not. So here's a space where you're actually implementing the Declaration of Rights of Indigenous Peoples Act. And now what we're asking is the federal government to do the same. So on all levels of government, whether it's the province of BC or Canada, we're asking the government, follow your own laws. This is law, Bill C-15 in British Columbia, it's C-41 in BC. Follow your own laws and don't break it. So this is what we're asking. Thank you.
That's all the time we had for this press conference. This will conclude the press conference. C'est ce qui conclut cette conférence de presse. Merci.